practice out in Bluebell. We're very grateful to her for stepping in and filling a gap in our schedule. And really, what she's sharing about, though, we are filming these presentations. What she's sharing about is something that's one of our most, family issues are probably about a third of the clients that we see across all of our clinic sites. And so if you're considering volunteering, equipping you with this information, this training, is actually very helpful to our ministry. And it's something that I've not learned much about myself, and so I'm really excited to have Maryann share with us. And Maryann, if I've left anything out, if you want to jump into your bio a little bit more and share any other salient details, feel free. But otherwise, I will turn it over.
Thank you so much, Seth. I'm going to come up and sit up front. I brought you treats today. I brought you dessert. Natasha tells me that if you answer the questions right, you get an extra. So if you don't mind, I'm going to be a little casual, mostly because I am really tired. I wanted to share a little bit about me in this way with you in this small group kind of situation. Share with you a little bit about why I've gone into family law and what I think about that as a lawyer and as a Christian. And partly because I think this area, in many ways, in the conservative church, is looked at as kind of off the beat. What are you doing in this area? How can you be a Christian? How can you call yourself Christian and be a lawyer, particularly practicing in this field? Doesn't God hate divorce? And so I think that I struggled through all of those things about 20 years ago, a number of years after I had gone through a difficult divorce myself, and I wanted to, at the end, I always want to make comment that God has certainly redeemed much relationship between my ex-husband and myself. We've been divorced for 27 years, and we are good friends, and he's coming over next week to fix my ponds in my backyard. So, I mean, God redeems, God reconciles. And the issue that I dealt with, my testimony, is that about 20 or so years ago, after I'd been practicing as a general litigator for about 10 or 12 years, God started knocking at my door and said, I want you to go leave the practice that you're in, even though you're a single mother of a child, and go practice family law. And I said, you gotta be kidding. And I said, no, I'm not doing that. That's a nasty business. Nobody in my church will ever talk to me again. And it's bad enough being, at that time being divorced, a single mother. I don't want to be a divorce lawyer too. And I made that very clear to God. And I started reading my devotions regularly. And Isaiah says, stop doing wrong. Can't read. Learn to do what is right. Seek justice. Encourage the oppressed. Defend the case of the fatherless. Plead the case of a widow. Come now, let us reason together. Now, that's not the only passage. I'm picking that one. But I will tell you that there are close to 50 or more passages in the Old Testament alone that talk about defending the cause of the fatherless or the widow. So I'm listening to this, I'm reading this, and no matter what I did, no matter where I studied scripture in my devotions, I couldn't avoid these passages. So finally I'm saying, well, I can defend the cause of the fatherless and the widow, I'm a lawyer, I can do that. So to God I said, okay, I will do that. I have to make one comment in between there. In one of my fights, one of the last fights in that regard, I was walking down the steps arguing with God in the middle of the night because I knew there was chocolate cake in the refrigerator. And as I was going down the steps, I broke my toe. And I thought, well, at least I'm not like Jacob and I didn't have to break my whole leg. So, and I will say to you that being a lawyer generally, is, as a Christian, you will struggle with these issues continually. You struggle with moral issues and ethical issues continually. If you are an elder in a church, you will struggle with ethical and moral issues continually. And both of my brothers, Pete, who I know is an ordained elder, both of my brothers are elders in their churches. And when I speak with elders, they come back with, when I joined this church, when I took this position, I did not realize that 60% of what I had to do was marriage mediation and family issues. And so, as lawyers, I tell you that, sorry if I get preachy, because I'm really tired and then I don't talk. Then I don't be quiet. As lawyers, we have this particular way where we, more than pastors, more than elders, more than family members, more than friends, we stand in the shoes of our clients. We are with them when they are going through the battle. We are with them. We are their mouthpieces at that hearing. We are with them in that place. Now, I told you about widows and the fatherless. I have a lot of clients who are very wealthy, and they also are broken. And the issues that we deal with in the clinics, we'll talk about some examples when we're dealing with crime and death and all kinds of issues that are layer and layer and layer of problems, and the issues of the greed and the other sins we deal with in the office. There's overlap all in every direction. Is all coming from great brokenness. And there are times when the only person that the client trusts in those situations is the lawyer. We may be the only person who has voice with that client. And we have voice not only as lawyer, but we often have voice as Christian, as brother or sister in Christ, to help them to manage through the spiritual warfare that they are dealing with. And if you undertake this task as Christian and as lawyer, and June as mediator, God bless her, you will be in the front of the battle. And today, I'm sorry to say that I'm a little bit battle-worn. So, and you will taste that, and you will taste not only the battle in the courtroom, that's one thing. That's not hard. What's hard is the spiritual battle, and you will taste that hard. Now, at CLC, we do not represent people in divorces, and a lot of that is because divorces per se, and a lot of that is because many of our donors struggle with that issue, and I think that that is a reasonable position for the clinics to take when representing people there. However, we talk to them about those issues, and we talk to them about custody and support issues. As a family lawyer, when I'm dealing with a divorce issue, there are 4 areas that I'm going to be looking at. One is divorce itself. One is distribution of assets as a result of the divorce. Another is support, and another is custody. Today we're going to be focusing on issues of support and custody. When I have a client come to me, I'm going to just share this little bit with you, and partly because Pete and his partner, Jeff Drake, helped me to work through a little bit of this. Even though God himself, and I was going to read that passage in Jeremiah, God himself says that he himself is divorced. He divorced Israel. He reconciled with Israel, but he says he divorced Israel. So he also says in Malachi that I hate divorce. I hate it. And he hates it because marriage is such an important part of our society, and because it is God's device, one of God's main devices for revealing who he is. Marriage is a covenant, and it reveals 2 things. One, God's covenant between Jesus and his church, and the other is the interwoven, intricate, heavy, deep relationship, intimate relationship among the Godhead. So when God speaks of marriage, he speaks of covenant. So when a Christian, particularly, and I will tell you that on a personal level, am I allowed to do all this stuff? Okay. I'm sorry I wasn't here earlier. I really apologize. I had to do a few more things to get ready to come. I had to go buy the candy. Oh, and please forgive me. I was going to say his first words out of my mouth. Natasha did all this work for you. Yay. And Courtney put it all together, and if I did not have had them, I would be rambling on incessantly about nothing. So really thank them for their hard work. Natasha particularly did a hard job of putting this together for you. All right. When I have a client come in who purports to be a Christian, and they say, I believe in Jesus Christ my Savior, go to the evangelical church, I'm having an affair, and I want a divorce. I ask clients two things, and I figured that since marriage is such a high idea in God's mind, since it is a covenant, and it is so precious to God that, and He says, and you hear this often in marriage vows, let no man take this asunder. Well, guess what I'm doing? I'm taking these things apart that God has made. So I figured that on the last day, I'm going to be called accountable. And I don't know what to do with that because I know He called me. So here we're dealing with this dance. Natasha's dealing with this dance. A lot of you are dealing with it. And so I figured that the only thing that I can do is take a look at this and understand divorce from theological views as much as I can, and then come back to the client and say, I'm going to ask you two questions. One is, are you, in your own mind, have you looked at this before God? I know you're miserable in your marriage. And the Bible also says, for instance, that a wife who is unloved shakes the earth. Not any woman, not any unloved person, but an unloved wife shakes the earth. So these people come in miserable. They're going through a lot of brokenness. Okay, but here's this one who is a Christian. So how do I balance this? Okay, so first question is, have you looked at what the Scripture says? Have you studied it? Are you clear and at peace before God that if you were to move forward with this divorce, this is right before God? And then secondly, have you, in the context of your church, looked at whether or not the church may not sanction what you're doing, but at least will acquiesce what you're doing. May not support you in the sense of every piece of it, but at least you have that they will acquiesce to and understand that what you're doing makes sense. And I guess those two things. The second part, because there is a gamut of views within Orthodoxy, I think, that will deal with that issue with the client. And I say to go back to your church. Don't go church hopping. Go back to what your church is saying and what your pastor is saying to you on these issues. You could put, this is my Presbyterian coming out. You were put in that church, not put you there. And so that's where you start. Don't go searching around for something otherwise to support what you think because it feels good. It's hard. Work it through. And sometimes, of course, I preach at them, and I'll tell you that I've worked it through. If you're interested, I'll just mention one more thing. I was going to bring this, I forgot. There's a book. The author's name is House, and it is the best that I've read. I haven't seen anything like it since it was published 20 years ago, where he edits the views of four separate, this is heavy theology, very astute theologians from four different views and on divorce and remarriage, and they all come back and criticize each other. So they write their view and then they critique all the other views, which I think is really helpful in understanding this from that perspective. All right. Now, what we're doing when we deal with divorce is we're taking this idea of marriage and we're dealing with the issue of we're dealing with issues of custody and support. We're taking this idea of marriage and we're putting it into a legal system. And the legal system is faulty. And so the common complaint that I hear all the time is, why isn't it this instead of this? And you have to go through and take the arguments that you're hearing from this client, and they may be very rational. A lot of our clients are very rational. And we say that our law, and if you listen to, we go to a lot of the, especially the statewide Bar Association meetings. I was on the legislative committee in our Bar Association for a while. There is a lot of argument and discussion about the arbitrariness of the development of this law. And so we were taking a law, a human law, and we're taking this family that's supposed to be ebbing and flowing, and it's not working. And they tried counseling, set rules, and that didn't work. And so now we're coming into a legal system, and that is arbitrary. It can't fit into your family. You're saying, I want a law to work for my family. Well, we don't have millions of laws to work for millions of families. We have one law, and there are pieces of it that are not going to make sense to you, but that's what it is. And when you are separating in marriage, that's what you're going to be looking at. The law is not going to invade a marriage that is whole, and we don't want it to, right? We don't want the law to come in and say, just because you guys are fighting about who should pay what bill, that you're able to sue that person. That's inane, and that is, that is not the kind of social contract in which we want to engage. We want the law to be minimum, and so it is. In considering issues of custody and support, the first thing that we want to look at is whether the people are living separate and apart. There have been changes in Pennsylvania, very recent changes in custody and support laws, that orders can be established in custody and support even if the people are still living in the same household. And under Pennsylvania law, long-standing under Pennsylvania law, people can live separate and apart in the same household. Now you will see in the outline here kind of some rules about what that will look like. I'm looking at this hour, it's such a short period of time. I'm looking at this as kind of how I would speak to a client. And it says, about some of these issues so we can kind of cut through it. All right, so just bear with me as we do that. So a client comes in and says, okay, I'm still in the house, we're both still in the house. We have several clients in our office now who, if they were to live separately in separate residences, basically they could absolutely not afford it. So they're living, while they're going through this process, they're living in the house separate and apart. After you get through all this initial stuff, I say to the client, okay, in order to establish living separate and apart in the same household, what I want you to do is go out and have what I call a Starbucks meeting. You tell your spouse that we're going to meet at Starbucks, and this is why, you're not going to have a big fight at Starbucks. And you both drive separately, and if it gets too heated, you can leave. And so you buy the coffee, even lunch. And so you sit down and say, this is what we're going to be talking about. I think that we're having difficulty in the marriage. I want to be separated as of today. So you're establishing intent. This case law says that you must establish intent of separation to be separated. In order to do that, we're going to figure out what bills you're going to pay, what bills I'm going to pay. I say to my clients, if you're both in the same bedroom, you move out of the master. You're going to fight over who's going to be in the master bedroom. It's not going to be a long haul. Even if it is, these are not the issues that you want to be squabbling about. Leave the master bedroom. You're in separate bedrooms, and then you begin to live as roommates. So you have, don't eat dinner together. Don't fix the oil in her car, and don't do his laundry, and whatever. It sounds kind of sexist. It works that way. I wish I had somebody to do my laundry. Anyway, but you want to live as roommates, and you want to be respectful of one another in that regard, and living as roommates. So if you're going to be out all weekend, you, now wife, who's coming to me and saying, I want to separate because he is having affairs under my nose, you can't complain anymore if he is gone. You're living as a roommate. You're living separate and apart. But be courteous to one another. If he's going to be gone all weekend, he should tell you that, as you would if you were, college roommates or something like that. So that these are these factors that are going to establish this living separate and apart. Big other factors are, don't hold yourselves out to others then as being married. You can be courteous to one another, but don't hold yourself out to your friends being husband and wife. Another big issue, begin separating your accounts, your bank accounts and your investment accounts and your other funds. People think that this living separate apart idea means don't ever have sex and never go on a family vacation or those kinds of things. That's not enough. And moreover, that may not be the measuring rod. So now, obviously, if you are coming together continually and it's all, and you have just this big ambivalence, you're not living separate and apart. Now, under present law, even if you're in the same household, the law will consider, although the courts don't like, having custody and support orders. So I'm going to talk to you about custody first. You do not need to have a divorce filed in order to pursue custody or support in Pennsylvania. Our custody law changed dramatically about 2.5 years ago. This idea of the best interest of the child in Pennsylvania used to be, and still is, and basically it's true in all 50 states, predominant concept. And let me just say this. If you have any questions or you want to interrupt and say, what about this, please feel free to do that at any time. Okay, and we're going to throw some things at you toward the end, but I wanted to make sure that I'm not just throwing words out here. Because you ate lunch, now you're full, now I give you candy. I'm trying to perk you up with the sugar. All right. So the idea ideas in custody have changed. This is the idea of best interest of the child. It used to be that there were some concepts, common law concepts, not particularly statutory, that the law would consider in regard to determining how custody should be considered. So we look at status quo, who has been the primary caretaker of these kids in the past. We would look at stability of the household. We look at what the work schedules for people are. Sometimes there's a part of the statute that referred to looking at certain criminal records, but it was a little bit messy as to how much a judge is going to look at these things. We look at preference of the child, and in some states, the preference of the child can be determinative at a certain age. So I'm not positive, but I think that this is true in New Jersey. So a 14-year-old can kind of make a decision as to what their custody schedule is going to look like. Not true in Pennsylvania. In Pennsylvania, and this is still the case, the court says, law says that we're going to consider preference of the child, but we're going to look at the age, maturity, education, and ability of the child to participate and to state a preference. We had a case, we had a case this week, it's kind of interesting, where a child was 14. And it seemed to be blowing up. The case seemed to be blowing up. And there was no divorce filed. It was a Christian couple who were struggling. And what to do with this and how to handle this situation. What I thought to do, because the preference of this child is now going to carry weight, a mature 14-year-old. So his thinking may make a difference entirely about how this case is going to proceed. And father thought that the custody should be one thing. He wanted shared custody, and mother thought, no, father's dangerous, and child doesn't want to live with him, and I want to have primary custody. So that's a big dispute, big issue. So I suggested to the other lawyer, who I like a lot. We ended up settling this. We're fighting. I would like a lot. We fight like cats. There's Ellen Sweeney, you know. So we fight. We fight like cats, but we really like each other, respect each other, and then get the thing accomplished, get it done. So we raise all the issues and get the thing done. So I said, Ellen, why don't we just talk to this kid? Why don't we have this kid meet both of us at the same time to see what he's really thinking? Because you're hearing one thing and I'm hearing another thing, and that's really common from a lawyer perspective. Unlike the judge or unlike a psychologist, we hear one side, and you have to always be mindful of that kind of situation. Anyway, it turned out that we were able to resolve this. Parents kind of figured some things out, and we resolved it on a temporary basis without speaking with the child because he was nervous to speak with the lawyers. He didn't want to be in the middle. Another really common thread, and let me say this, in every single custody case that I have ever tried, two things are true. One is, my client has always come off the witness stands and said, I mean, there's like some book written someplace, and they will always say, you told me that was going to be really hard, but I didn't think it was going to be that hard. So, trial is tough. And the other thing is, now you have a child in the midst of this, and I have never seen, now how we do in custody trials, how we deal with the children, is not on the witness stand. I say this, rarely does that occur. If there are two lawyers in the case, child goes back to the judge's chambers with the two lawyers and a court reporter, and the judge, and generally the judge, and often the lawyers, ask the child questions. The child dances. They all dance. They walk down this tightrope like this. I like being at mom's house, I like being at dad's house, and I want to be with both of them, and I wish they would stop fighting, and I wish they would get back together. They almost always say that. It doesn't matter how old they are, it doesn't matter, and the parents will swear on the Bible to this child that they want to be with me. Of course they do. And of course they do that. So, we're coming back and dealing with those pieces. All right. So let me come back to this changes in the custody law. It used to be that the status quo piece was almost always determinative in where that child would go. So, if you have mom who has primarily with the kids and works here for loud, etc., child would always go with mom. I will say that when I went through all of this myself, now 27 years ago, I'm a grandmother, so. I was working at that time in a big law firm. I was working 70 hours a week. And there was almost no question, there were other issues involved, but there was almost no question that I would have primary custody of our son. I think he's okay. Now, where the law has changed significantly is in a couple of factors. One is, rather than having these kind of vague principles out there as to what the court is going to consider in determining what the best interest of the child is, Pennsylvania statute has set forth 16 factors. You have them in your materials there. Some are in the outline and some are in the materials. 16 factors that the court is now going to consider, must consider, and if there is a court decision, the court now has to write a memorandum opinion outlining how they dealt with all the 16 factors. So it used to be judge could hammer a gavel and say, custody here, this is primary, this is partial, here is shared legal custody, and that's it. Now the court says, no, you have to write an opinion now, dealing with all of these factors. By the way, I have rarely had custody orders do that. I mostly have had some kind of opinion, either from the bench or in writing, but now they have to do it. Issues like status quo are not so much the criterion as who is going to provide a more stable life for this child. Now, status quo kind of finagles in that way, but the criteria now are a little bit different. One of the Another factor is we used to use these words joint custody and shared custody, and people talk about I have full custody. Well, full custody doesn't mean anything. Let me go through these terms a little bit that might be meaningful to definitions of custody basically are these. We have physical custody, meaning where the child is residing. And that is either primary, that is the child mostly lives with one parent, partial, the child lives with that parent sometimes, overnights with that child sometimes, and shared, meaning that it now looks more equal. It may not be exactly 50-50, but something looking like shared is what is now using that term. Shared custody now is viewed by the statute as the preferred way to handle a custody situation. So the statute says this, kind of read it to you, but this is the idea, that if one side wants shared custody and the other side wants primary custody, the court has to now consider what that shared custody is now going to look like. Now, I'll tell you, that has followed some social changes. 27 years ago, when I was going through this, it was typical for the mother to be more involved in the lives of the children. The father was involved, but not nearly so much so as the mother. Before that, I was dealing with this as women were working more and more in the workforce. Before that, of course, a lot of women stayed home. And so while shared custody is now becoming the norm, in some evangelical circles that becomes more difficult because that's not the norm in some conservative circles. So where the father is more out in the workforce and the mother is more at home. But that is a push now for the shared custody. And there is a societal change that supports that the fathers are much more involved in the caretaking of the children than they have been in the past. Sole legal custody means that's what people kind of think is full custody. No, sole legal custody means exclusive, or sole custody means exclusive custody. So that sole physical custody, exclusive physical custody means that one parent has the child and the other parent does not. That is extremely rare, and it happens only in cases of grave danger to the child. Maybe a parent is in jail, something like that, or the criminal is in grave danger. I told you before that the court now has to consider these factors so that they have to now consider whether or not there's a PFA, protection from abuse order out there against the parent. They have to consider certain crimes that a parent may have committed, including DUIs, which was much less clear under the old statute. All right. I'm going to talk about this a little bit. There is kind of an in-between between a partial custody, which means that the child has time alone with the parent for some of the time, and exclusive custody. And maybe you have somebody who is a recovering drug addict, or maybe you have somebody who is sort of dangerous but not entirely. That person may be subject to supervised physical custody. In Philadelphia, supervised physical custody can occur, still as 1801, I think, with the sheriffs, which is kind of miserable. There are no substantial programs in the outside counties to create supervised custody. There isn't anything. There are a couple of private programs where you can hire some of these supervising counselors to do it. They're very expensive, and some of those people are just not very good. And so when I'm looking for a supervisor, if we need to have that in a case, I like grandparents, church people, that you want somebody who both parents can trust, even though one parent is struggling themselves. Remember, we're dealing with broken people. And I think that having done this practice now for over 20 years, that the thing that hits me in the face regularly is that I'm broken too. And that, but for the grace of God, I'm that person, or that person, or that person. And one of the spiritual struggles is how much these things hit you in the face that can be met. So, and so you, of course, as a professional, doctors here, I deal with that on my knees, and make sure you do that every day. I only mean that because that's the only source of wisdom to get through the day. And then, in front of this person, you're clear as to the next steps that they will be taking through this system. They need clarity. That's what they're looking for. They're not looking for softness.
In that situation where you've got the custody battle, I know in Philadelphia they appoint a representative for the minor in certain hearings.
Mm-hmm.
Does that play out in this area as well? So we're talking about custody. There's a court-appointed lawyer for the child. You maintain those interests in consideration, or is it just the mother and the dad lawyers fighting it out?
So you're describing a child advocate. There is a very strong child advocacy program here in Philadelphia, and I actually started doing child advocacy myself when I was a very young lawyer. It's a good, by the way, if you're a very young lawyer, you want to sign up for something that is a good pro bono project besides CLC, which is the best, Frank Cervone still monitors child advocates program in Philadelphia, and he's excellent. The program is excellent here. And the first child that I was ever a child advocate for is now 34 years old, and I have continuous contact with her. So, so that it can create a lot of opportunity for involvement in somebody's life. Child advocates are generally appointed. There's a good, by the way, there's a new program in Montgomery County as well that Risa Furman and Wendy Demchick Risa Furman and Wendy Demchick really started about 10 years ago, and I will participate in starting up that thing too. And Natasha and I both are MCAP lawyers, Montgomery County Child Advocacy Program lawyers as well. And they are appointed, child advocates are appointed by the court in two kinds of situations, kind of sua sponte by the court. One is in PFAs where children are in the middle of the issue and are sought to be protected parties. And two is in heavy-hitting child custody cases where the child, again, is in the middle and there's danger. Usually there's an issue of physical danger to the child. However, if you are representing a parent or you think that there may be some issue of physical danger, particularly with the other side, right, you can request and file a petition for a child advocate to be appointed in those counties where that is permitted. In other counties, and I have had this happen a couple times, there are GAL programs out there, and mostly coming through the Children Youth Services programs, and you can, without involving, we can request appointment of a guardian ad litem for a child, which is a different role than a child advocate. The child advocate is the child's lawyer. The guardian ad litem steps in more of a guardianship type, more of a guardian type of role. Not guardianship, it is for the purposes of the litigation, but it is a different role than the advocate. Anyway, so the reason why I said to do that for the young lawyers is you get to go to court, and you can see stuff going on in court. If you want to be a courtroom lawyer, it's a good way to kind of observe how stuff goes on. All right. Legal custody is the other area of definition. Legal custody is who makes the decisions for the major events in the child's life. And in the church, where we have difficulty, and I will tell you that this comes up with regularity, is religious decisions. And generally speaking, the law is that either parent can inculcate the child in whatever religious beliefs they choose, as long as there's no substantial harm to the child. Now, I will tell you, I had a case some number of years ago now, where my client was a Christian, had some kind of little bit of cultic beliefs, but had some ideas, and was truly a Christian, conservative Christian. And the mother, to whom he was not married, 2 children, The mother was a non-practicing Jewish woman. And the mother's lawyer somehow finagled, and you can't do this anymore, but there's law against this now, but she finagled without my client's knowledge. That's the piece. You cannot take children to a psychologist without both parties now agreeing. And if you ever hear of a psychologist undertaking therapy of a child in any way without the other side's permission, that is against all kinds of APA regulations and the law. So you don't want to, that's a rare event anymore. But at that time it wasn't so rare. Takes these kids to a psychologist who comes in and says, if you teach these children Jesus loves you and sings Jesus, and children sing Jesus loves you, this I know to the mother, and they have an understanding of hell, and these children were about 5 or 6. That is causing them substantial psychological harm, and therefore the father should have no contact with the children. That position was actually taken and set forth in a courtroom in a case that I had. So you will, that strength of that position doesn't occur so much anymore, but I haven't seen that much, but there is this influx of these children shouldn't go to Christian school because they badmouth me because I left the marriage, says one parent. Or these children shouldn't go to this church because they teach against divorce. So those kinds of issues come up all the time. And with shared legal custody, these decisions need to be made with both parents. So how are you going to do that? One of the things that I say to clients is, you know what? Getting through this next period is going to be completely counterintuitive because your marriage is falling apart because for various reasons you don't trust each other anymore. Now, in order to make this go through and to help you to co-parent and to help you to get to the other side, you have to learn on a different level to trust that person again and in a different way. And you're doing it now for the benefit of your children, who you purport to love more than anybody. Although I will tell you that what people are willing to do to their children is sometimes astonishing. And they don't see it. They don't see what they're doing to their children. All right, I'm going to move into this support piece a little bit. If you want to have me, I'm going to put this on here. As I said, you can read this stuff, and if you have questions, you can ask us or name all over this stuff. So please feel free to do that. Oh, I did want to say one thing before we move to support. I'm going to talk about alternative dispute resolution. I should have June come up here and talk about alternative. June is my favorite mediator on the planet. In Montgomery County and in some of the other counties, parties, before they proceed with any custody litigation, are required to at least participate in a mediation orientation session. And the idea there is that people can come up with their orders and their agreements better on their own if they put some effort into it rather than a judge hammering a gavel. And so this idea of alternative dispute resolution is, in various ways, is a really positive device. I would just make a little side comment, and I don't have time, but I just came back from South Sudan a little bit ago, and where we did a conference with lawyers on dealing with various issues. And one of the things we talked about was mediation. This is and I was struck by the intricacy of knowledge of these lawyers in South Sudan on alternative dispute resolution devices, and how they were generally within their communities, within the tribe instead of within the courtroom. But there were all these devices. So this is a worldwide technique. I was just really struck with the development of that idea. Anyway, what we do is, if mediation is not effective, if people can't do mediation, what I will often do, if I'm sending a client to mediation, is have that client report back to me what's going on, so that they're not agreeing to something that is so off the charts that's going to cause them problems. So we talk about it on this side. The lawyers do not go, generally, to mediation sessions. What lawyers will do, though, is meet with clients and parties in a conference in either kind of a straightforward meeting to see if that will work. And there's another whole area of practice that many lawyers are engaging in, not Christian lawyers particularly, it's just a whole other area, called collaborative law, in which the parties and the lawyers all agree that they're going to sit down and, in a series of meetings, work out their case. And if they can't work it out, the lawyers quit and somebody else litigates it. So, it's a very strong effort to deal with alternative dispute. Arbitration is also available, but that's expensive and unusual in custody and support cases. Arbitration, you understand, is a paid, binding judge who will make a decision in regard to a case. And the judge is not somebody who wears robes, but generally a lawyer who is experienced in doing this practice. And that is very common in other areas. You hear a lot about union and employment arbitrations, that kind of thing. It's also true in family law. And we see that more in higher end cases where people can afford it. Okay. Child support laws changed a little bit too. Let me just go through that quickly and then do a couple examples. Basically, Pennsylvania, like most of the other 50 states, have actuarial tables which consider lifetime income effect and needs of families in regard to the day-to-day budgets of families. And those actuarial tables are called the Pennsylvania Support Guidelines. And what they do is, depending on the number of children in a family, is pit one person's income against the other person's income. In Pennsylvania, we do not consider expenses. In Pennsylvania, we do not, let me make it real clear. We generally do not consider expenses. It is an income-driven analysis. Expenses can be considered if they're extraordinary, and there are certain provisions for deviation from these guideline rules. The spousal support is also considered in determining income before you do the child support piece. So I'm going to move over now to spousal support, and I should have given you the chart here, which I didn't, so I'm going to just give you a little imaginary chart. All right, so there are three kinds of money that a lower income spouse can get from a higher income spouse. So think of the timeline, here it is. And the first kind of money is nothing is filed, no divorce is filed, custody may be filed, and maybe we filed for child support. Lower income spouse now says, I want spousal support from that one because, she makes a heck of a lot more money than I do, and I've been here taking care of the kids, and I'm going to be getting this child support. So they apply for child support, for spousal support. And usually you do it at the same time that you apply for child support. Well, the spousal support can be paid from the time that, excuse me, from the time, sorry.
It's not a city bug. I was not riding a motorcycle.
All right, thank you. All right, spousal support can be paid from the time that it is filed and after the parties are separated. Generally, that means living in separate residences, but not always. So that if you have a spouse higher income spouse who is collecting all this money, depositing it into an account, and not helping to pay any of the bills. So remember, I had that Starbucks meeting in front. We talked about who's going to pay the bills. All right, bills are not getting paid. The parties are living separate and apart in the same household. Now the lower income spouse can come in and try to seek spousal support. The burden there is a little bit higher. You have to really show this court that these bills are not getting paid and that these things are not going on, and that you really are living separate and apart. All right, and that can continue until the divorce is over, that spousal support thing. There's a big problem with it. And there's a big issue that spouses who seek support have to deal with, and that is entitlement. And I call it the bad spouse defense. So, husband says, you make a lot more money than me, wife, I'm going to sue you for spousal support. And wife says, wait a minute, you are fooling around with the neighbor, that chick flew down the street, and I have evidence of that, and so you're not getting any spousal support because you're not entitled to it. Or she says, you know, you hit me over the head with frying pans, whatever you do. So you're not entitled to spousal support because of these indignities, which are tantamount to fault divorce. So these indignities are tantamount to showing that. Or you left and I wanted you to stay, and you left. And I tried to work this marriage out and you went by yourself. You went off by yourself. You're not entitled to spousal support now. All right, so that's what that means. Spousal support, by the way, works like this. Before any child support is calculated, you take the net incomes of the parties. And remember, when you're dealing with W-2 income like we do, or no income, like we do at CLC, this is not too difficult to do. So you take the net income of the parties and you take 30% of the difference of your nets, and that is what the non-spousal support is. That's the formula. It gets more complicated, of course, when you have businesses, when somebody has a business and their income is not so easily defined. All right, the other place where it gets complicated is I just lost my job, or I lost my job a year ago, or as Natasha handled a case this week, I was laid off from my job 7 years ago and haven't been able to find new employment. What does that do? And now we have an issue of not only actual income, but of earning capacity that we want to take a look at and apply the same formula. But you see, this is all income driven, and except for certain exceptions. All right. The next area, though, is something called alimony pendente vitae. And that looks like spousal support, acts like spousal support, walks around like spousal support, but it's not. It's not money that you pay to the lower income spouse because they're entitled to it. It's money that is paid after a divorce is filed to the lower income spouse to help them to deal with the divorce issues. So it's a different animal. But it looks like spousal support, same formula, same calculation. And that also can be paid until the divorce is over. No entitlement defense applies. What applies, though, is if the other person does not need that money, the person applying for ADL does not need that money, or is delay the divorce proceedings, because you get it in order to help you through the divorce, anticipating that there's other money at the end. And then finally, the other kind of money that one spouse can pay to another is alimony. And that is very different. That's paid after the divorce is over. I know we're not talking about we're supposed to be talking about support, and this is a little bit different, but still money paid from one spouse to another. After the divorce is over, we look at income, but that's only one of a plethora of factors that we look at to determine whether or not alimony is appropriate in a case. All right. Now, I think I have 5 more minutes. Are you all exhausted? Do you need some sugar? You can have it. Although I'm supposed to, I hear from Natasha Courtney that I have to bring this back and fill the jar up, which is empty in our office. Okay. So here's some, I'm going to ask you a couple law school issues on the back of your outline there. I'm going to throw out a couple others. Some others that we see. And I will tell you that this is such the tip of the iceberg of dealing with these issues that, very difficult cut through. All right. I'll share a case that we actually had in the clinic. And part of the reason why I want to share this is that I'm utterly convinced that the people involved in this, that at least our client, the clinic's client, was a couple who were godly people. And they were dealing with issues, including criminal backgrounds and things that were very complex. So this was the case. Grandmother and grandmother's husband come in, and they had a daughter, and this daughter had a child, and the daughter died. The daughter was actually shot. And the daughter had issues, and of course we didn't learn this until later, but the daughter was a stripper. And the grandmother was, from time to time, caring for this child. Actually I think there may be two children in this case, because there were two fathers, both of whom were incarcerated. At the funeral of the daughter, the other grandparents came in and took the children and wouldn't give them back. And now we have an emergency custody situation, and there were no parents. There were only competing grandparents. Now, I'm going to skip over the standing issue. There's an issue of when and where grandparents have standing, and that can be a little bit difficult. And in this case, the children had been, or the one child particularly, had been with both grandparents periodically over time as the mother was in and out dealing with her drug issues and her stripper issues and she got shot. When we looked at the family history of both families, and I'm telling this story because this is what we see in the clinic. This is what you see this is what you see, and it's real. These people were genuine. In both backgrounds of both of the families, there were criminal issues, criminal backgrounds of both of the men who were living with. I think one grandmother was married and the other one was not, but they were men who'd been living there for a long time and acted as the step grandfathers of these children. All right, what happens with custody? Okay, I know you want to talk.
Okay, in this case, the fathers are present or they're not present?
Both fathers are incarcerated.
Both fathers are incarcerated and the mother's in and out of jail.
The mother is dead.
Oh, the mother's dead. Okay, so it's both grandparents that
Grandparents
are bringing the action.
bringing the action. Yeah, grandparents fighting.
Okay, so both grandparents are fighting.
Yes, it's
Yeah.
not mother, it's not parent against grandparents, grandparents against grandparents.
So, and they're both coming in, they both have right to come in, so they're both asking for.
Right, there's some standing
Right.
issue, but
Right.
they're both.
Okay, so, are you going through, so are one of the grandparents is trying to get sole legal?
Right, each grandparent's trying to have primary physical custody of the child.
And sole legal custody?
Yeah,
So either they're going to go into mediation and talk about it and figure out what they're going to do, or are they going to have a third party make the decision for them? I mean, that's basically what's going to happen at that point.
mhm. So what do you think should happen?
Well, I mean, as a mediator, they would, hopefully they'll both be talking, having a perspective,
Okay.
looking at the best interests of the child. What you try to do is get them not to look at themselves and be
Right.
kind of selfish, but to look at the best interests of the child.
Right.
And generally, and I think, although I don't make decisions for them, but, to have both sides of families in their lives, generally, unless they're, as you said, unless there's something going on that's really wrong. So hopefully, talking it through, they'll come out with some kind of situation. Sometimes people are very far apart, so you have to figure out a way that the child's not going to have to travel 2 hours to school, so they're making a determination as to what's in the best interest of the child.
Nikki?
It would seem that one of the children is not blood related to the people who took them, right? because they have different fathers.
Correct, they're different,
Same
actually,
mother, but different fathers.
right, and so we have paternal, right, that's true, but the child, both children had been involved with both grandparents.
Whose lawyer am I?
We represented, at CLC, we represented the mother of the mother.
I think in one regard, this is still a parental issue. It's just up one level generationally. And I'm going to assume that the 16 factors that would affect the husband and wife would all come into play here. The difficulty is on an emergency hearing, you don't have a whole lot of time to get your ducks lined up and those factors analyzed. But the judge is going to look for what makes best sense for the child's best interest, and they're going to look at the economics, the time spent together, and most of the judges I know in Philadelphia are going to try to mediate and have something shared. But emergency petition, you have to vigorously and zealously for your client. I've got to push all the factors I can to support my client as long as it's not adverse to the best interests of the child.
Okay.
So your judge is going to give you a temporary order, bring you back in 90 days, and order all kinds of investigations, psychological tests, income stuff, and then they'll make a final determination.
So, I'll tell you what happened, and in light of the 16 factors in a situation like this. What's messy about it is, again, it's grandparents only, but that's not an unusual situation if we're dealing in here in Philadelphia, and some sections also even of Montgomery County. It's not unusual. And also, and the law provides for that. One of the areas we did not talk about was this big standing piece and how you deal with third-party standing in this area. But here we had grandparents against grandparents, so that issue is lighter. But an emergency, in this case, by the way, Regina Guerin handled primarily, and I was supposed to pick up some of it, but I started to have a little bit of difficulty with the client who was in the trip. Anyway, but God bless her, and, you know, I'm convinced, you know, believer. She, so what ended up, an emergency petition was filed, and I think that she did that initially on her own, and she was very upset because she had, it was a shared custody arrangement between she and the other grandparents. And she had traipsed back and forth, and she was, as is typical, she would call regularly with, what about this, and what about that? And the child was late for school, and I can't pick up the child this week, or they want to go away, and I can't, and I don't want them to, et cetera, et cetera. All of those issues were very hot. And part of the reason why they were so hot was her daughter was killed, and the other grandparents took the children at the funeral. And she's dealing with level, and there's criminality, there's issues on both sides, and she's got financial issues, and there's level. But ultimately, that's what happened in the emergency piece, and the final result was very similar to what the emergency piece was. It screamed, and you're hitting the nail on the head, it screamed that the children were close to both of these grandparents, did not have contact with the parents, and the court allowed opportunity for essentially mediation, although they did it right then and there to deal with that.
One of the things I'd say that differ if you're doing biblically based Christian mediation is you are looking at the hard issues. So there's more of a chance that you would get to the underlying issue as to what was happening, and hopefully get it resolved at the hard issue, so it makes it easier for you to resolve, you know, some of the more substantive issues. So in a Christian one, you're not just looking at the substantive issues, you're also looking at what's going on in the heart of people. So, you know, from a biblical point of view and just as a relationship point of view.
And just as a plug, June and Pete as well are very well trained. I just had initial level at Peacemakers Ministries, and which is a Christian mediation organization that we like a lot. So, okay, I think I'm well beyond my time.
Yeah, so let's give Maryann a round of applause.